Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 144 of the NCDWI Guy podcast. On today's episode, we have SFST, ARIDE, DRE guru, Anthony Palacios back on the podcast. If you are involved in DUI defense in the United States of America in any meaningful way, you very likely know who Anthony is. He is a legend, if I can call him that, within DUI expert circles in the country, nationwide. Just an amazing expert to have involved on your case. Anthony was on the podcast back at episode 20, where we discussed horizontal gaze nystagmus in depth. Go back and listen to that episode. You will not be disappointed. Anthony, anything that Anthony is doing education-wise when it comes to CLE, when it comes to his own trainings, when it comes to being in the courtroom, and anything that he is doing related to a DUI investigation, how it's supposed to be properly conducted, is just gold. So go back and listen to episode 20. On today's episode, Anthony and I are taking a deep dive into drug recognition experts, why the DRE program, why DRE officers are in decline. This is something that I have noticed in my personal practice and really kind of across the state, a more declining use of DRE experts in DUI investigations related to non-alcohol cases. And so, why is that? We're going to talk about that. But again, more importantly, Anthony is going to be doing a deep dive into what the DRE program looks like, encompasses, what the 12-step evaluation that a DRE does looks like. And I think this can be incredibly powerful. Take a listen to today's episode. I think this can be incredibly powerful if you have a case where a DRE is not utilized. If you have an ARIDE officer or just an SFST officer get involved in a case, does a positive or does a PBT, shows negative for alcohol, and that then basically says, well, must be some other impairing substance going on, get a blood test, and boom, we send it off to trial. This is going to really help you be able to use the lack of a DRE being involved in your case in the defense. So really, really powerful stuff from Anthony. To give a brief background on Anthony. Anthony is a nationally recognized impaired driving consultant and expert witness. He's based in Atlanta, Georgia. Anthony is a former SFST state coordinator for the state of Georgia, as well as a former SFST DRE staff instructor for the Georgia Police Academy. Because of his expertise in teaching the NHTSA impaired driving training curricula, Anthony was hand-selected by NHTSA as one of only a few SFST instructors in the country to serve on a national SFST training curriculum assessment team. In 2018 and again in 2022, Anthony was the recipient of the Best of the Best award from the National Association of Criminal Defense Lawyers, an honor given to the top 20 CLE speakers in the country. Anthony has trained over 5,000 law enforcement officers. I'm going to repeat that. Anthony has trained over 5,000 law enforcement officers, prosecutors, defense attorneys, and judges in the NHTSA impaired driving training curricula, and has been a guest speaker at over 40 national and state impaired driving conferences. If there is education going on related to a DUI, Anthony wants to be involved. And so we are very grateful to have him on the podcast today to just highlight a couple of trainings that Anthony has coming up. He is in March 10th to 12th, and then again June 23rd to 25th, doing the SFST, the 24-hour DWI investigation and SFST training course that is offered to officers in Atlanta. So if you have the ability to attend one of those trainings, if you've never done the 24-hour NHTSA program, it is game changing. This is where every one of our attorneys at the office, this is like the starting point for CLE, is to go to Anthony's 24-hour NHTSA class. It is really, really well done. By the book. Anthony is very, very consistent with that NHTSA training. He's doing it multiple times a year, and it is just jam-packed with information that is so helpful in terms of understanding how a DUI is supposed to be properly investigated, and how the standardized field sobriety tests are supposed to be performed. So take a look at those. I highlighted again a couple of weeks back his 8th annual Super Symposium, which is coming up in Savannah, Georgia on February 2nd and 3rd. There will be several attorneys from our office at the Super Symposium, and he's got just an incredible lineup of speakers for that symposium. So make sure that you go and sign up for those events. If you're interested in any of the events that is, or any of the continuing education courses that Anthony puts on, and there are a ton, if you go to his website, go to impaireddrivingspecialists.com, impaireddrivingspecialists.com, and there you will find all of the trainings. If you go to DUI seminars and CLE training, you'll see a whole laundry list of different courses that Anthony offers. He does a DRE overview training. He does an ARIDE training. So again, go check out his website. He also has a kind of subscription education model called DUI Expert on Demand. That is also available at impaireddrivingspecialists.com. So go check that out. And Anthony, in addition to all of those trainings and his incredible background, he still does expert analysis on DUI cases and testifies in the courtroom about any number of these different areas, SFST training, DRE, ARIDE. So think about having Anthony look over your case materials or come in and speak as an expert witness. And finally, Anthony will be speaking at the Freedom Fighter Summit October 19th and 20th in Asheville. So very, very excited to have Anthony be a part of our conference. I'm just very, very excited about that. Anthony at the conference in October is going to talk about becoming the SFST courtroom expert. You know, how that can change your practice, becoming the SFST courtroom expert. So excited to have Anthony be a part of our conference. And there's no better person to talk about the value and the way to become the SFST courtroom expert than Anthony. Very excited to share this episode with you all. Anthony, it's great to have you back on the podcast. You know, last time we were getting into the weeds when it came to horizontal gaze nystagmus, and this time around we're going to go into the weeds on becoming and executing the drug recognition expert training. So excited to have the conversation with you and very excited to have you back on the show.
Well, I appreciate the invite back.
So in terms of kind of the DRE process and evaluation, I think to kind of give some background into your experience, expertise in this realm, tell me just, or tell the audience a little bit about kind of your personal kind of experience as a DRE instructor, you know, what that has kind of looked like, you know, from the beginning. So maybe we step back and kind of just start out with personally the DRE training that you have both received and given.
Well, I went through DRE practitioner school back in 2001 when I was on my agency's DUI task force. And of course, I was nervous as can be when I was told that I was going to the course, because I was just, everyone has in law enforcement had heard how hard that training was. I ended up going to the training course. Somehow I ended up passing it. I was one of the few in my class. We started with 20 officers and graduated, I believe it was like 8 in the class.
Statewide in Georgia, or what was the?
Yes, that was statewide. Absolutely. Okay. And after graduating DRE school and becoming a certified DRE, obviously I went back to my agency, started utilizing the training. Shortly after becoming a certified DRE, I actually was transferred off the DUI task force and ended up going to our accident fatality investigation unit. I was still able to obviously use the DRE training if I was investigating a fatality that possibly involved drug driving. In 2003, I was invited to attend the DRE instructor course. Went down to the Georgia Police Academy, attended that, passed that, became a DRE instructor. And not long after that, I ended up applying for and getting accepted and hired as one of the DRE staff instructors at the Georgia Police Academy. So my last 4 years in law enforcement, a little over 4 years in law enforcement, I actually was one of the DRE staff instructors, where I was teaching the DRE school along with the other NHTSA courses.
Yeah, that's awesome. And in terms of the kind of training that you did through the Georgia Academy, how often were the DRE courses taught? What did that, how many classes per year did that generally kind of run?
When I was at the police academy, we ran the DRE course twice a year, once in the like early spring and then once in the fall. One of the reasons being is because of the fact it's just not classroom training, which I believe we're going to get into in a little bit, but it's just not classroom training. After the classroom training, we had to calendar in what's called field certification time, where we went around the state with the students and helped them get certified that way as well. So we had to build in a lot of time for the DRE training.
And in terms of current current training on the DRE front, with your company, just tell the audience a little bit about kind of the classes that are offered currently in terms of DRE, either the DRE school or kind of a similar program to what the DRE school looks like, as well as any other kind of DRE related trainings that you currently do.
Well, as far as the DRE training itself, I cannot offer that because of the fact that attendees have to be current law enforcement officers to attend the actual DRE certification. So what I do offer for legal professionals is just a 3-day DRE overview training, which covers the 12-step DRE process, all the training the DRE has to go through, how to review and evaluate a DRE case file. And we also talk about the drug symptomology chart, better known as the matrix.
And I think, one of the things that we are, I guess, trying to address in the conversation today is really a kind of lack of utilizing DREs in the field in real time on DUI cases. And so, the background on that end from your side of things, I think is important because, again, I think sometimes in the courtroom, you might be, kind of questioning as a defense lawyer, is this DRE kind of properly executing their training? Are they following the training that they received in the DRE school? Is there a question about their certification? What was this, again, properly executed in the field? And so I think that background is important in the sense that when the DRE training is properly instructed and given and then utilized by officers, there is a real value to having that additional instruction. So in terms of just kind of the layers that an officer generally would go through in terms of doing the standardized field sobriety testing 24-hour block, and then going into ARIDE, and then going into DRE. Can you talk a little bit about that progression of kind of the differences at each one of those like main training blocks?
Absolutely. The foundation or in the backbone to the NHTSA impaired driving training curricula is without a doubt the DWI detection and standardized field sobriety, the 24-hour alcohol class that almost everybody is familiar with, law enforcement wise and attorney wise. Once an officer goes through that training course, then they are qualified to move on to the NHTSA ARIDE training course, the Advanced Roadside Impaired Driving Enforcement. That training curriculum is fairly new compared to all the other NHTSA training curriculums. It's been out since 2008. There was a different version of ARIDE prior to that was called Drugs That Impaired Driving, which was only a one-day course. ARIDE's a 2-day course. And a simple way to explain ARIDE is it's pretty much the standardized field sobriety course for alcohol, but for drugs. It teaches officers how to establish probable cause during a DUI investigation out in the field. They're taught additional tests to use, and in addition to the standardized field sobriety test, and they go over the ARIDE version of the drug symptomology chart or matrix, which just teaches the officers what different drug categories will cause different indicators, different symptoms in somebody. For the purpose of that training, in my opinion, it is good training. It does do what it's designed to do for that officer, which is establish probable cause out in the field. Once an officer goes through ARIDE and they start becoming experienced in DUI drug detection, then they can apply for the drug recognition expert school. And of course, that, as you know, is without a doubt the cream of the crop, if you will, as far as impaired driving training is concerned in NHTSA and law enforcement.
And in terms of the kind of difference between ARIDE and DRE specifically, what is kind of the, for somebody that's kind of gone through that drug recognition expert course versus just the ARIDE course, what is the kind of difference in terms of whether it's actual knowledge level, or in terms of what NHTSA considers the difference between those two officers to be?
Well, I'll tell you the main two differences, other than the training, the amount of training they receive, but the main two differences between an ARIDE officer and a DRE officer is, one, as I just mentioned previously, an ARIDE officer's training is designed to establish probable cause, where a DRE is brought in after the fact, after the arrest, to do a 12-step eval, and their opinions designed to prove someone guilty if they feel they're under the influence beyond a reasonable doubt. Their training brings it past probable cause. The other main difference is an ARIDE trained officer is not qualified to give their opinion on a specific drug category, to where a DRE, when they come in and they do the 12-step evaluation, their opinion based on their training, they're allowed to give an opinion of what drug category someone's under the influence of. So those are the two main differences.
And in terms of, that specific distinction, and I think, in North Carolina, under the rules of evidence, Rule 702, we have kind of that spelled out in terms of a DRE can offer their opinion as to a specific drug category, as to a specific substance that a person is impaired on, kind of explaining the difference between being able to say this is the drug category that I thought the person was impaired on versus not, would it be kind of inappropriate, generally speaking, at least under the training, for an ARIDE only trained officer to say, I thought that this person was impaired on this specific drug?
Absolutely. As a matter of fact, there are several locations in the ARIDE student manual that tells an ARIDE trained officer they are not qualified, at least under NHTSA's opinion, they are not qualified to give their opinion on a specific drug or drug category.
And I think there's a real disconnect, and I think it's important to have, a conversation about this, as well as, kind of go back to the manuals. I mean, not necessarily in today's call, but where this is spelled out in the manuals, because I think that this is a real difficult misperception. The way that I see a lot of drug investigations work, and kind of how they play out then in the courtroom, is that an officer stops somebody, thinks they're impaired, does a PBT, person blows zeros. Okay, well, now it must be something else that is causing impairment. This person is not acting right. If they've been through ARIDE, maybe they do some of those tests, or maybe they called out, another officer that is ARIDE certified that does these, the full battery of SFSTs and additional field sobriety tests at the roadside. But, after all of this investigation, make an arrest, go get a blood draw, whether by warrant or some other exception. And then basically the idea is, okay, whatever shows up in that blood is what's causing impairment. Or maybe I found a pill bottle, or maybe this person told me that they were taking this particular type of medication. But there's never that either reach out to a DRE, or a DRE is not available. And so I think that the way that the state a lot of times will kind of attempt to prove guilt on the DUI then in the courtroom is, okay, judge, you saw all of this strange behavior on the roadside, and the blood test came back with this substance showing in, which, is an impairing substance. Therefore, that substance must be causing this impairment. And so, sometimes, and I guess this is where my question kind of comes in. Sometimes the officer will try to use what the ARIDE officer has learned in their ARIDE training about this specific substance, showing these particular indicators and clues of impairment that maybe they saw in the investigation. A lot of times it doesn't get that far, but if they're kind of like doing everything they can in the courtroom to explain why this person is guilty beyond a reasonable doubt, they try to use the ARIDE officer to kind of connect, okay, what I was seeing in these field sobriety tests, or droopy eyelids, or different things that we'll get into in just a minute, what I was seeing at the roadside correlates with this thing that was found in the blood. How much of that is allowed in terms of kind of correlating, for purposes of proof in the courtroom, those things that are seen at the roadside with a specific drug that's found in the blood?
Well, as far as ARIDE officers, and as far as what the training curriculum allows, a ARIDE trained officer can testify to all these general and major indicators because they do receive training on that. But according to the ARIDE training curriculum, they can't take that last step and say, which means, in my opinion, Mr. Smith was under the influence of a CNS stimulant. They just can't take that last. They can't take that last step as an ARIDE officer.
And so this is the leading question that is asked, at least in North Carolina, on every DWI case by the prosecutor. I'm going to get this. I'm going to butcher this, but it's definitely the most commonly utilized leading question in the state of North Carolina. Mr. Officer, did you form an opinion satisfactory to yourself that the defendant's mental and or physical faculties were appreciably impaired? The officer says yes. And then, and what substance did you think caused impairment? And then, in a lot of cases it's alcohol, but then in one of these, drug related cases, whatever substance is found in the blood. That question, would that be kind of considered under ARIDE training through NHTSA to be an inappropriate question for a NHTSA officer?
For an ARIDE trained out officer, absolutely.
Yes. Okay. Yeah. So I think that's the place of kind of challenge point, at least as to that. Cause again, I do think that you get to talk about, even if you don't have an ARIDE officer, you get to talk about all of the signs and indicators that you're seeing at the roadside. This person seemed to have droopy eyelids. They seem to have slurred speech. They struggled when they stepped out of the car. All of these kind of typical signs and indicators. And it may be the case that those signs and indicators are bad enough in and of themselves on some cases that you may really have difficulty in the defense position arguing against that. But where there's not a lot of those signs and indicators, then I think sometimes what happens is that ARIDE training really then is what is being relied upon by the court to basically say, okay, well, this person, even though they seem, to be answering questions okay, and there's not a whole lot of like physical signs and indicators, the ARIDE officer is indicating that they believe the person was appreciably impaired by drugs, and specifically not only this category of drugs, but this specific substance. And so that's where I think that there's a lot of problematic testimony that comes out in the courtroom.
Absolutely, because that goes, at least as far as the NHTSA training is concerned, that goes totally against what the ARIDE training curriculum allows ARIDE trained officers to do, as far as taking that last step and giving their opinion of what drug category. They're just not allowed to do it based on NHTSA's training.
So I guess before we kind of get into maybe why that so frequently happens, we'll save that maybe for a little later in the conversation. Tell us a little bit, Anthony, about what the DRE training process looks like. What's required to become a DRE officer?
Well, there's the DRE training is actually broken down into 3 different phases. You have what's called phase 1, which is the preliminary school. It's a 2-day training, classroom training. Once the DRE candidate passes the preliminary school 2-day training, then they transition into the actual 7-day DRE training school. Once they graduate that, then they move into what's called phase 3, field certification, which as an instructor, or at least a former instructor, that was always our most favorite part of the training, is the field certification. But there's certain things which I believe we're going to cover here in a little bit, but there's certain processes that have to happen during the field certification phase. Then if they pass that, they take what's called the final knowledge exam. If they pass this final knowledge exam, then their paperwork's sent off to IACP to become a certified DRE.
And I guess just in terms of following up on that, let's dive into the field certification stage, but also just one kind of quick preliminary question. Is there any kind of similar field certification that happens with ARIDE?
There is not.
And so what does that then look like, once you've done the 7-day DRE school, what does that look like in terms of the field certification side of things?
Well, with the field certification, NHTSA requires a DRE candidate to conduct a minimum of 12 evaluations. Now, a lot of folks are familiar with the standardized field sobriety training course, the 3-day training course, what's called the alcohol workshop, where instructors bring in volunteers and then dose them with alcohol in a controlled environment. And then the police officers going through basic field sobriety get to conduct field sobriety in the classroom on the volunteers. That's all a controlled environment. With the field certification in DRE, that's obviously doesn't work quite like that. Instructors are not allowed to bring volunteers in a controlled environment and give one volunteer methamphetamine, give one volunteer LSD, and obviously that's illegal. We're not allowed to do that. So
it would be fun for some of the volunteers, but
well, yeah, it may. I agree. So with the field certification, the instructors, the students will stay in a classroom at a local agency somewhere. Oftentimes that's how it is. It's at a local agency. And then the instructors and officers from that local agency, whether it's the traffic units, DUI task force, whomever, they would go out into the field, and if they encountered someone who the instructor or the officers thought were possibly under the influence, then they would bring that subject back to the classroom and let the DRE candidate do an evaluation on that subject. Now, obviously, these evaluations are being graded by an instructor. Every step is being graded by an instructor. There's a checklist that the instructor's using to make sure the DRE candidate is doing the eval exactly the way they're supposed to. So the student or the candidate has to do a minimum of 12 of those. They have to do the eval correctly, and they have to give their opinion. Out of those 12 evals, the candidate has to be the actual evaluator in 6 of them. They don't have to be the evaluator in all 12. On the other 6, they can just be a witness of the evaluation, or what's called the scribe, taking all the notes. But no matter what their role is in that evaluation, they still have to give their own opinion, and they still have to turn in their own DRE narrative. NHTSA requires that out of the 12 evaluations, that at least 3 different evaluations, the DRE has given 3 different opinions. And actually, it doesn't have to be in 3 different evals, but let's say, for a good example would be, out of the 12 evals, the DRE candidate can't say cannabis on all 12. Gotcha. NHTSA wants them to have experience in different drugs or drug categories. So they have to have at least a minimum of 3 different drug categories during those 12 evals. The subjects or volunteers are tested on site. They give, most often it's going to be obviously urine samples, and the instructors test them on site. That way, obviously, the DRE opinion or candidate opinion can be confirmed or not on site.
And in terms of the opinions that are given, is there any requirement that a certain number of those be correct, or does that not really play into kind of the next stage in terms of that candidate becoming certified as a DRE?
There absolutely is a requirement. So the way it works is, out of the 12 evaluations the candidate has to do, at least 9 of the evals, a biological sample has to be obtained. Out of those 9 biological samples, 7 of them have to be correct or match the DRE's opinion. So that it comes up to 75%. The DRE has to be correct 75% in their opinion.
Okay. Yeah. I mean, I think that, in terms of, just that overview of what kind of going through the DRE training process looks like, the instruction and field evaluation process. I think one of the things that can be done in terms of us as defense lawyers talking in the courtroom about this is just to kind of have a way of explaining that to the court. Here is what is required to become a drug recognition expert: the level of training, the level of oversight by another officer that's already in this role. Here's what in real time the evaluations have to be in terms of accuracy. And all of that really is missing in ARIDE, with the exception of, a minimal amount of training. All of these extra kind of precautions and instructions are being had by the DRE that's gone through all of this. And so I think just explaining that, and part of the issue with doing this in the courtroom is it's somewhat difficult to do that without having either your own expert or calling a state DRE to come in and talk on this issue, because most ARIDE officers, if you say, do you know what is required to become a DRE? If they're smart, they'll say, not really. I don't know. That's above my pay grade, or whatever it might be. Which is that's the smart answer right there, is to just kind of leave that to, but don't put on yourself something that you don't have the ins and outs of. But if anything, additionally to that, they'll just say, well, I know it's a 7-day course, and there's certain additional things that are taught during that, but it's very vague. And so I think that part of showing to the judge or to a jury the different level of experience and training that an ARIDE officer goes through versus a DRE officer can only be had by bringing in your own expert witness, such as yourself, or getting a state DRE to come in and kind of talk about the program and what is different about that. Now, it's dangerous potentially to bring in a state DRE because you don't know what they might be able to kind of talk about in terms of connecting signs and clues in your case, but at least you could have a conversation about what that training program looks like. So it really is, I think, powerful in terms of education to the judge or jury to talk through these steps.
And to add to that, Jake, one thing I've learned that a lot of attorneys don't realize with ARIDE is the only training course out of the three, out of the basic field sobriety, ARIDE, and DRE. ARIDE's the only training course where after the ARIDE officer learns these new tools that they're supposed to use out in the field, they do not get to apply those new tools on a subject who's possibly under the influence prior to using it out in the field. As I previously mentioned, with basic field sobriety, the officers learn about how to administer field sobriety, then they use it in training on these volunteer drinkers. DREs, they learn the 12-step DRE eval during the field certification phase. They have to prove to their instructor they know how to apply this knowledge before they get to use it out in the field, or before they get to do a real eval, an enforcement eval. To where ARIDE, that doesn't happen. The ARIDE officer learns all this new knowledge, and it's great knowledge. I'm not minimizing it at all. It's great knowledge, but they do not get to apply it hands-on on someone possibly under the influence until that first enforcement investigation. And a lot of, like I said, a lot of legal professionals don't realize that.
Yeah, I think that's really powerful. I mean, that nothing really to add on that front, but I think it's important to point that out when you're in the courtroom, that there was no field evaluation that took place based on these tests. In terms of the kind of actual process for doing a DRE evaluation, what does that 12-step process look like, kind of in big picture form? You don't have to go into the nitty-gritty of each single step, but what does that look like in terms of, I think one of the things that, again, we may just leave vaguely out there in terms of the 12 steps is that it's basically very very similar to standardized field sobriety testing, or you don't really get, a whole lot of, if you don't get kind of through some of those individual steps, I think it's easy to kind of, miss the nuance that is happening in a DRE evaluation. So yeah, just in big picture format, what does that 12-step evaluation look like?
Well, in big picture format, it is extremely standardized. It is extremely systematic. A key to the 12-step evaluation is it's post-arrest, and it is always done in a controlled environment. A 12-step DRE evaluation is not done out in the field. And it's one of those situations that during the actual evaluation itself, it is so controlled that, let's say hypothetically, a DRE officer is the one that made the arrest out in the field. And let's say the DRE officer did some exams or some tests that actually are part of the DRE process. Let's say the modified Romberg balance and finger to nose, and obviously basic field sobriety. They do that in the field. Well, when they go back and the DRE ends up doing the eval, they have to redo those tests all over again because now they're in a controlled environment. So controlled environment is critical. But within the eval, on average, as long as the subject's cooperating, on average, it takes about an hour to do the evaluation. A lot of the 12 steps have multiple steps within that step. The very first step the DRE has to do is rule out alcohol as the sole cause of impairment. So a breath test has to be taken. The next step would be if the DRE is not the arresting officer, then the DRE would take some time and sit down with the arresting officer. That would be step number 2. Step number 3 is a critical step. It's called the preliminary exam. That's pretty much the medical assessment step. So the DRE has already ruled out alcohol. Now during step number 3, they will conduct some tests to rule out medical impairment. And once the DRE goes past step 3 and determines it's not alcohol impairment and it's not medical impairment, from step 4 on, that is all the steps they will do to see if the driver's under the influence of a possible drug or drug category.
Just to interrupt you real quick on that medical impairment side of things, a lot of times on DWI investigations, whether it's for alcohol or drugs, if it's just an officer, whether it's with no training or all the way up through ARIDE, what they'll typically say in the courtroom is, based on my HGN, analysis, there was no medical impairment going on. I did the medical check off in HGN. So, I knew there was nothing medical going on. In terms of making sure, again, there's not a medical issue causing impairment, how does that differ in the DRE evaluation of step 3 versus just saying, well, I did the HGN and the person didn't have a medical issue that appeared?
There are a lot more steps that the DRE has to do. Now, obviously, I would say more, I feel comfortable saying more often than not, the DRE isn't going to have any medical training as far as being like an RN or a doctor. So even though the DRE is doing a lot more medical assessment wise than the basic ARIDE trained officer or field sobriety officer, they're obviously still, again, they're not doctors or they're not nurses. Right. We acknowledge that. But one step that they do during the preliminary exam is ask easily probably about 8 to 10 questions off what's called the DRE face sheet. They'll ask, are you sick? Are you injured? Are you diabetic? Are you epileptic? Do you take insulin? Are you under the care of a doctor? And of course, if the subject says yes, then there's follow-up questions. Are you taking any medication? If the driver says yes, there's follow-up questions. A DRE even goes as far as asking, are you under the care of a dentist? So, and if the driver says yes, there's follow-up questions. So there's standardized questions that have to be asked. Then the DRE will do actually what you were talking about earlier with a field sobriety officer. They'll take a look at the eyes. They'll check for pupil size. The tracking, they'll look for equal tracking. And during that time, they'll actually do an initial onset as well, which is obviously part of HGN. But they will also take the driver's first pulse at that time. So as far as medical impairment, although it's more than your basic field sobriety officer, as you can see, it's not that much more. And it usually takes maybe 5 minutes. And that's one of the, at least in my opinion, that's one of the unfortunate situations the DRE finds themselves in is, we don't have a lot of medical training, and we have to make a determination, within approximately 5 minutes, is this medical impairment or not? And, and as everyone knows, you go to a doctor's office, you're there for a lot more than 5 minutes
Right.
in order for a doctor to give an opinion. So, that's about what goes on during the preliminary exam.
Okay. And in terms of then the rest of the evaluation, what other kind of major points, if any, for the rest of the 12-step evaluation?
Well, as far as major points, there's, as far as tests are concerned, obviously the DRE is going to do eye exams, the typical HGN, VGN. They'll do lack of convergence. They will spend some time in what's called a dark room, where they're estimating the subject's eyes, their pupils. They're estimating their pupils in 3 different lighting conditions. Again, very controlled. They'll have the driver do psychophysical tests, which most folks are used to the walk and turn and one leg stand, but then the DRE will add on the modified Romberg balance, the finger to nose. So there's additional psychophysical tests that are done. But again, the key here is it's in a controlled environment. And then there's a step where most drivers are not used to officers doing. And it's almost like playing doctor a little bit, although again, we're not doctors. But the DRE will take some time and take the person's blood pressure, body temperature, and during that step, take the pulse again. So there's certain, without getting in depth with the stuff, but obviously there's certain drug categories that will cause someone's blood pressure to be elevated, someone's body temperature to be elevated or depressed. And that's the reason why DREs will do that. But again, the key here is, again, the main takeaway is everything's done in a controlled environment, and it's done post arrest.
And in terms of one of the steps, is that include potentially taking a blood sample or some sort of sample from the suspect?
It is, and that's actually the very last step. After the DRE goes through the first 11 steps and eliminates alcohol, it's a sole cause impairment, eliminates medical impairment. The rest of the steps is where they determine whether or not the person's under the influence of a drug. If they end up having that opinion, which is step number 10, is when they give their opinion or formulate their opinion, step number 11, then they will move to step number 12, the last step, and that will be getting a blood, urine, whatever they decide to get.
And so I think this is important as well, because in terms of when the opinion is formed, I think a lot of times the way that it works for ARIDE officers or anybody with less training than ARIDE is we're going to operate with kind of getting our looking to the answer key and then kind of fitting our investigation, so to speak, into that. So, I think this person is impaired by something. I don't know exactly what. I'm going to ask for a blood test to get done, see what comes back in the lab. For the drug recognition expert, that opinion is getting formed at the time of the investigation prior to any result coming back from either blood testing or urine testing.
Absolutely. When they reach they being the DRE, when they reach step number 11, they are formulating an opinion on 2 things. One, if the driver is or is not under the influence at the time of the evaluation. And 2, if the driver is under the influence at the time of the evaluation, what drug category they're under the influence of. So that is done real time at the evaluation.
And I think that that's really, again, somewhat where the rubber meets the road in terms of issues within in the courtroom? Because again, I think a lot of times the way that these kind of cases are presented is there was a roadside investigation by the officer. There was, a feeling by the officer that the person was impaired, and then blood results showed X. And so in terms of the way that the DRE evaluation process, the 12-step evaluation, kind of the import of the blood sample within that 12-step evaluation, what is the kind of importance of the blood sample itself when looked at in the context of the entire evaluation?
Well, really the blood test result is just used to confirm or not confirm the DRE's opinion. Let's say hypothetically, if someone refused the blood test during step number 12, obviously that DRE has already formulated their opinion, and just because the person refused, just like in an alcohol case, the DRE is not going to change their opinion. The blood results may come back and have multiple different drugs in the system, but the DRE had opinion of just only one of those drugs that came back in the blood out of the 4. That would tell a defense attorney that the DRE did not think the person, although it was in their system at the time of the blood draw, they were not under the influence of B, C, or D, just A.
Yeah, and I think I guess maybe we can kind of talk for a minute, if you can speak to this a little bit, maybe about why DREs aren't being utilized as much. Again, with all of this training knowledge, the much more rigorous evaluation in a controlled environment that's happening with a DRE, it seems like that is on the decline. And I've had 2 cases recently that came back within the same week. My clients both blew negative at the roadside. One of them was involved in a minor accident. Another person hit a telephone pole. Officers come out. They do the initial investigation. They think there's something odd about the way this person is answering questions. They do the PBT zeros. Okay, well, let's see if we can get a blood sample. And so they sent that off. And in both cases, it came back with nothing at all in the blood, whether it's alcohol or drugs. One client had actually suffered or not suffered, but was basically suffering from a cancer in his brain, and it was getting progressively worse. He basically had this discovered shortly after being released from jail. He had fallen down. Somebody came to help, goes to the hospital to get an MRI done, and the MRI reveals, you've got a brain cancer going on. We need a brain tumor. We got to operate immediately. And then in the other case, client had hit a telephone pole, had worked 3 consecutive 12-hour shifts at the hospital, was headed back into the hospital, was fatigued, hit that telephone pole. And so I don't know if it was being tired or some sort of a medical issue going on, but again, concerned about, hey, why are you acting strange, or these signs and indicators. And again, these are cases that will never be really seen by a judge or a jury in terms of what's pretty problematic, that they were charged with driving while impaired when there was really nothing at all in their system. And I think as much as those are maybe outliers in terms of drug cases, they actually happen, regularly. There's times when just nothing comes back in the blood. And I think part of that is because, officers that are making these arrest decisions, have pretty limited training, but then there's not that kind of further step that is taken to show, no, what was actually being observed at the roadside wasn't anything else, fatigue, medical issue, I had one client that I think was probably arrested because he was just a bizarre dude. I mean, he was just I spent 10 minutes in the office talking to him, and I was like, I can see why the officer charged you with with driving while impaired, but he wasn't on anything, it was not taking anything. And so I think that's why these cases are so important. And so I think what happens is that the only ones that seem to get prosecuted are the ones where there is something that shows up in the blood. And basically, again, it's this kind of like backwards math where we work from the answer and try to kind of fit it neatly into the investigation. So with all of this training that DREs go through, with all of the tools that they have at their disposal, are you seeing kind of less utilization of DREs? And if so, kind of, why do you think that might be?
Nationally, I am absolutely seeing less use of DRE officers conducting DRE evaluations. My opinion is kind of twofold. One of the reasons I feel like it's happening is because of ARIDE. ARIDE training has absolutely exploded, and I am seeing a lot of ARIDE cases. And I believe the reason why more ARIDE cases are coming out versus DRE cases is because ARIDE training is designed for the officer to make the decision at roadside, establish probable cause, and they're done. Whereas a DRE, as I mentioned, it's post-arrest. So now you have to take an officer off the road. As I mentioned, it takes about an hour to do an evaluation. So now you're taking that officer out of the road or off the road for another hour to add on to a traffic stop where an arrest decision's already been made. And then putting that aside, you have the training aspect. As I mentioned, ARIDE is 2 days, and then the officer can start utilizing the knowledge they've learned, to where DRE is 2 weeks of classroom, but then they're not even done. They have to go into these field certifications, to where in some states that could take up to 3 or 4 months, not every day 3 or 4 months, but 1 or 2 weekends a month for 3 or 4 months to get the evals done. And then finally, after those 2 or 3 months, then the officer can start using their training. So it just, unfortunately, I think there's some states and agencies out there that don't feel that the time constraints that it takes to do an eval and become a certified DRE is worth sending their officers to DRE school. And it's unfortunate because, as I think we both agree, it is necessary and top of the line training if the evals are done correctly.
Yeah, and I think in terms of bringing this into the courtroom to kind of help kind of see how is this information, how can this information be utilized by defense lawyers? What is the importance of having a DRE involved? Again, the way to really bring this out to a judge or to a jury is to have somebody that can speak about the DRE training, the DRE 12-step evaluation, the field training that is done, to be able to talk about all of those things. Because one thing that I think is important in terms of phrasing certain pieces of evidence is, when you're in a criminal case, you would prefer to have kind of the best evidence that is available to prosecute on. If there was, a means of getting kind of the best possible evidence when the standard of proof is beyond a reasonable doubt, it only makes sense for the state to want to do that. So, for instance, in a refusal case, there are certain officers that if the person refuses, they say, okay, refusal, done with my investigation. My question is always, well, did you have the ability to go get a search warrant to require a blood draw? My client did not consent to a blood draw. Did you go get a search warrant? Because again, that would tell us judge or jury if there was, a 0.08 or greater alcohol concentration. He had the means to do that. If there's video missing, that's the best evidence of how my client was acting. The state had the ability to have, this. You heard the officer say that his car was equipped with dash camera technology. He didn't utilize it on this particular day, or the technology didn't show the field sobriety tests. Wouldn't you want to have the ability to see that kind of best evidence? And so it's the same thing in terms of expressing this on the DRE side of things. You've got these officers that are highly qualified based on classroom work, based on being evaluated in the field by a supervising instructor, to be able to make these specific type of evaluations. Why would we not want somebody with those type of evaluations coming in and giving their opinion when a person's life is on the line? So I think getting somebody in the courtroom that can speak to that is so powerful, because as you're just talking about, really what it comes down to in terms of less DREs being utilized is, well, we don't have DREs to do these evaluations. We don't have the drug recognition experts in the local agencies to get this done. And the reason why is because of resources, right? As a state, we're choosing not to put the resources in to giving officers the time that they need to go through those trainings, to understand that officers are going to be spending a substantial amount of their time conducting these evaluations and covering these cases in odd hours as they come in. It's a resource issue. And so I think, again, it comes back to, well, people's rights cost money. I mean, that's at the end of the day, that's that, if we believe that, somebody's freedom is important, that, somebody's criminal record or lack thereof is important, and that people have rights, then, we should be, putting forth the best resources that are available, to make sure that happens. So, I think that's the way that we can bring that to life in the courtroom.
Absolutely. And I'll tell you that the NHTSA training curriculum has that same opinion. Both ARIDE training curriculum and the basic field sobriety training curriculum teaches the officers, if they feel like they have a DUI drug case, to call in a DRE if available. So all the way back to the basic field sobriety training, officers are being taught that.
Yeah, I think that's such a powerful thing to point out. And, this is an easy way to kind of address that with just the SFST trained officer or with the ARIDE officer, because it's in their manuals that they should be contacting a DRE if they think that somebody is impaired by a drug other than alcohol. But then again, I think you also need that additional, well, why do we want a DRE to come out? Obviously that's in the manual. And I do think that there is value, in that part of it. Did you, especially when the answer is, well, I didn't contact the DRE, kind of, it wasn't that there wasn't one available. I just, I didn't feel like I needed to call somebody on that front, which happens actually quite a bit. So it is pretty powerful to say, well, not only, did a DRE not come out because there wasn't one available, you didn't even try. Like, there was no attempt to get a DRE out here. So you're just not even following your training. You don't see that as important. But I think connecting that why of, okay, there really is such a superior level of knowledge by these officers that are DRE certified.
Absolutely. And I want to add on to what you just said. And I'm not trying to extend this by another hour. This would be another hour topic right here. But in lines with what we're talking about, I'm seeing quite a bit in cases that I'm getting where the arresting officer is a DRE and he or she's not going back after the fact, after the arrest, and doing an evaluation. That's problematic as well.
Yeah, that is problematic. Yeah, that's wild. That is a very, I mean, again, just nonsensical in terms of, how could you justify all of this training and money and expense going into this officer, and then them deciding not to utilize that. And, again, I think that the biggest challenge that I see, at least in North Carolina, and I really can't, maybe you can speak to this anywhere else in terms of other attorneys that you talked with across the country. But the main challenge, I think, even as a defense bar, is that, if there was somebody arrested for impaired driving and there's an impairing substance showing up in their system, they're pretty much guilty. Like that is kind of the mindset. And again, there's just so many more things when you're outside of the per se issue when it comes to, 0.08 or greater in North Carolina, or Schedule I substances in North Carolina. It's per se, it doesn't matter if, in those cases, DRE or no, it's just, was this in the system at the time of driving? That's it. That's the end of the game. And maybe you can challenge whether that's the right substance, or maybe you can challenge when it was actually consumed, but, post driving or not. But for everything else, again, just the fact that there is an impairing substance showing up in the system has to be, connected back to impairment, and that this, class category of drugs causes these signs and indicators, which is what the DRE is supposed to be doing. Do you see a lot of that kind of, working backwards on cases and in, other states that you're acting as an expert in?
I do. Now, obviously, if an eval isn't done, a lot of times I'm not brought in on the case where it's just like a blood case. Since I'm not an expert in blood, I wouldn't be involved. So I may not be seeing a lot of that, but there are some cases where like an ARIDE officer's involved. So I do get involved with the case, and I can see how they're working backwards on it, since they didn't bring a DRE in to do the evaluation.
Well, I think, that may be, kind of a good place for us to end, Anthony. I mean, I think that really the biggest concern is to try to figure out how to explain to a judge why a DRE is important. And I think the best way to do that is to get an expert like Anthony involved on your case, so that you can explain to the court or to a jury, here's the value that is coming in when a DRE gets involved. And that was missed in this case, that there was no, attempt to get this person out, or even if there was an attempt, here's why this is so important, that we're missing this big chunk of information that would really help us determine impairment. But any kind of concluding thoughts on your end in terms of how to use an expert witness on these type of cases, or what kind of the next step should be for somebody that has a DRE style case that they're trying to defend?
Well, with a DRE style case, as I think the theme has been this whole conversation, the attorney's dealing with a cream of the crop officer. So, and I'm not in no way trying to say, to reach out to me as an expert, but I'm just saying, I would think, in my opinion, it would definitely be beneficial for a DRE style case to have a DRE expert look at the case file to assist. As far as the takeaway with the ARIDE part of our conversation, I think the big takeaway here is just to remember, although the ARIDE training does do what it's designed to do, in my opinion, which is to help that young officer establish probable cause, that the takeaway is they are not qualified to give their opinion on what drug category the person's under the influence, bottom line. And I've been involved in some cases where the ARIDE officer gave their opinion, at least in the report. So, I mean, if they're giving their opinion in the report, I'm telling the attorney, you might want to assume they're going to try to give their opinion if this ends up.
I think it's extremely regular that they give it in the courtroom. I mean, yeah.
Yes, sir.
Yes, I totally agree with that. And I think that is a major point of emphasis, because that's so much a part of, again, the standard questioning from the district attorney to get to that. What did you think they were impaired on? and we should be screaming, from defense there that this is not an appropriate opinion. You might be able to say they were impaired on something, but that's not very helpful when it comes to getting a conviction. Well, I appreciate it very much, Anthony. I mean, it's just super helpful to get that overview. And I know you are just covered up in cases and trainings and teaching us DUI lawyers across the country. So I very much appreciate what you've done in terms of educating the defense attorneys, prosecutors, judges. I mean, I know that your training goes beyond just the defense bar. So I appreciate everything that you're doing to help us have a better understanding of the work that we're involved in.
Well, Jake, teaching's my love, and although I do have a busy schedule, I'll always make time for you. So I do definitely appreciate the invite.
If you found the information in this podcast to be valuable, I simply ask that you pay it forward and share this podcast with another member of the legal community. Also, if you would leave us a rating or a review on whatever platform you are listening on, I would greatly appreciate it.